All right, this is the Laws of Entertainment podcast interview with Christine Washington. Intellectual property basics, iTunes description. If you're serious about handling your business and media, don't miss this episode. Lisa sits down with Christine Washington, an intellectual property and trademark attorney. Christine is the owner of the consulting firm Marks for Music, Movies, and More. Her intellectual practice caters to the needs of artists, innovators, and businesses in all fields of media, online and traditional. Music, TV, film, and general consumer products. Christine has handled trademark matters for Kraft, Marlboro, Jive Records, AOL, Vivo, and more. Christine and Lisa talk about the fundamentals of trademark and copyright, the differences between the two, what is each, when you need a trademark, why you need one, and when to copyright and how. So, a little bit about Christine Washington. This is from her LinkedIn page. She's a trademark copy attorney, for brand management, licensing, clearance, transactions, law firm affiliations in New York and Los Angeles. And she went to Duke University School of Law. I'm not going to read through all of her areas of expertise, but she works mainly with trademarks, copyrights, and transactions. Client compliance attorney with entertainment, advertising, and retail background, and a proven track record in clearing, protecting, leveraging, and otherwise managing famous and large-scale brands, trademarks, portfolios, copyright catalogs, and business assets. So some of the main points that came out of the interview were the class of trademarks. The primary classes for entertainment were Class 9, and that's trademark Class 9 sound recording, and trademark Class 41, which is entertainment services. It was more explained, the entertainment services more explained like theater and those types of things. And you should always check to see if they're available, if the trademark is available in different classes, and check for a common law trademarks as well. A good example of the class trademark would be Dove Chocolate and Dove Soap. They both have the same name, but they're in different classes. And then also look for international trademark treaties, and always check in China to make sure you get your trademark there, because that's a first to file country. And then they talked about copyright registration, and this will give you federal jurisdiction and allow you to take action if you come across a case of copyright infringement. They did talk about the poor man's copyright. Technically, if you just write something down, or you're, post it to a website or take a picture of it, it is copyrighted. But if you don't file that, it's hard to claim any type of copyright infringement. And then they also talked about legal help websites, and most of these sites are not geared for entertainment law. It's always best to hire an entertainment lawyer, because basically sites like LegalZoom and those things really are geared towards criminal or civil types of things, tickets, those types of things. So it's always best to get a copyright attorney like Christine Washington to help you with trademarks and patents and copyrights. So they did talk a little bit about patents, and the example they used for all three was, the logo of Coke sometimes is in cursive, sometimes, it's the Coke, the trademark, and then, the copyrighted, the bottle, the shape of the bottle, and those types of things. And then the patent would be the machine that actually pours the Coke into the bottles. So those would be the three different kinds of, three different legs under intellectual property that she works with. And then I didn't use too many references here, just the Laws of Entertainment podcast, and then the Christine Washington's LinkedIn page.